This Kohberger case just continues to be a puzzle with so many missing pieces. I don't know what to make of it anymore.
Yeah, and the more puzzle pieces you have, the less and less things seem to fit together.
I don't know. I really don't know what to say, but you know what? We have 5 more and maybe a bonus in this edition.
The more you look into the Kohberger case, the more confusing it seems, and none of the pieces really seem to perfectly fit together. On this episode about the law, I'm Lainey Law.
And I'm attorney Andrew Myers.
And we are going to dive into 5 more puzzling pieces to the Kohberger case. How are you doing today, Andrew?
Hey, Lainey, I'm doing well. How are you?
I'm doing good. I hope everybody had a wonderful holiday season, stress-free and relaxing. And if I hope that watching these confusing videos is the most stressful part of your holidays.
Well, I'd like to think that someone somewhere is not confused, the defense attorneys, the prosecutor. I'd like to think somewhere, somehow, there is a real theory, there is real knowledge. We really, that someone somewhere knows what's going on. And we just don't know because of the gag order and the sealing of nearly all, if not all, of the court documents. But the more I think about it and the more I read about it, the less I really feel that we're getting really close to what justice is all about. And the justice system is supposed to be a search for the truth. But I wonder if we'll ever really get there.
Yeah, I don't know. Even as we are right now, everybody has such conflicting opinions about everything with this. I think that no matter what's determined in the court case, I think that there's always going to be people questioning, what really happened, or is this right, or this or that or the other. I think it's going to be impossible for anybody to feel 100% confident.
Well, we have 5 more pieces of the puzzle as they exist at this time. And the first one is, and it's not as simple question as does the trial go in 2024, but that's where this piece kind of starts out. What happened more recently before we're recording this episode is that the prosecution filed a motion saying that they want a trial date, and they're requesting a status conference or a scheduling conference by the judge. And at that point, they will argue as to when they should have a trial. So we start out with a motion that was filed in court, and the motion was to have a scheduling order. And the prosecution is saying, oh, we're ready to go. Here we are. We want to have a jury trial, which we think will run about 6 weeks. And, I know elsewhere people would read you the whole thing. I'm not going to do that. I'm going to show you what's important. What's important here is that they're saying we want a scheduling order from the court, and this is fairly standard in any case. We want to have deadlines for completion of all the exchange of information between the prosecution and the defense. That's called discovery. Then they want deadlines under these Idaho court rules, 16B7, 12B, 16B6, 404B. What those rules say is that the parties in this case have to disclose who their experts are, how many experts they're going to be, what their credentials are, and each side will have to disclose their experts by a given time, and then the other side will have a given amount of time to respond. So that sounds pretty simple, right?
No, a little. It's like to have a schedule for all of that stuff. It's a lot of stuff to give. I can't even imagine putting myself in that. But to ask for that kind of stuff, fair.
Yeah, well, that's what a scheduling conference usually is, and you would think that'd be pretty simple. They want deadlines for disclosing their exhibits and all the rest. Here's something I found kind of interesting. Now, I've tried cases in big cities, and I've tried cases in little teeny tiny little towns here in New England. But here, the reason they want the case to start in the summer of 2024, in the early summer, is not because of any scheduling or we know everything there is to know or the experts are all available. No, check it out. Scheduling a jury trial to run for approximately 6 weeks, including the penalty phase. The state proposes that the court schedule the trial for the summer of 2024. and that the trial dates avoid times when Moscow High School and other area universities are in session. As the court is aware, Moscow High School is directly adjacent to the courthouse premises. And okay, that's enough. I mean, before I fall on the floor, I shouldn't laugh at this, but I've never seen a motion where you say, oh, well, the judge knows the school's next door and we don't want to interfere with the school buses, or, there's not that many hotel rooms around here. And so we want to make sure there's enough hotel rooms. Now, sure, a scheduling conference in any case is to establish deadlines for experts, for witnesses, and for other matters like that. Sure, you can discuss the local traffic and that sort of thing. And no, I'm not familiar with Idaho. I've never been there, but I've been in another little teeny tiny little state and other little teeny tiny little villages. And I don't know. I thought that was a little bit amusing, if not odd, that the prosecution would put that in their motion. I don't know. I've never.
There's levels to it, because I think it's funny that this is, like you mentioned, is just like, how often do you hear about court being held off because you want to make sure that the kids in the school isn't in session? But another thing that I wanted to ask you about, how common, if they say that it's going to take 6 weeks, how common is that it actually would take 6 weeks anyway? Because my thought is even if you're doing it over the summer, isn't there a chance that it'll go over the 6 weeks and then when school's starting up and oh my God,
Well, yeah, that's always an issue. But if you've been experienced as the attorneys here, I read that William Thompson, the chief prosecutor, has been practicing law for 30 years, as have I. And Ann Taylor's been practicing law for a long, long time. I mean, they're experienced. They know what a trial is like. They know, unlike us, how many witnesses there will be, how many experts there will be. So they have a pretty good idea, but it is unusual that one side says it's going to be 6 weeks. Usually that's something that the attorneys get together and say, okay, I have this many witnesses and this many exhibits. What do you got? And then after they go back and forth, they can actually, experienced trial attorneys can come to a fairly good estimate, but there's always wild cards. Like, we don't know. Will Bryan Kohberger himself go on the stand? Nobody in the world thought that Alexander Murdoch would actually go on the stand and testify, but he sure did. And he, if the jury hadn't already made up their mind, they sure did after he got on the stand and admitted that he lied. But anyhow, that I digress. So the answer to your question is, generally attorneys can come up with a pretty good faith estimate of how long a trial is going to be, and no good judge would hold them to that.
I do have a question on top of that.
Sure.
When they're saying for a 6 week period, I guess my next question is, how often are they going to be meeting during those 6 weeks? And also, would you say, is that short, long, or about average?
Well, the Murdoch trial was 6 weeks. That was a pretty complicated case, and they had a total of, I think, 72 witnesses in that case. So
that's a lot of witnesses.
That's a lot of witnesses. Generally, I believe the prosecution's request said that they wanted to try the case from 8 to 3 in the afternoon. So or 8 to 3 in the afternoon, which meant that, pretty much they had the time that they would spend on the case pretty much measured out. Does that answer your question?
I think so. I guess one more thing, is it like, are they going like once a week, or is this every day?
Oh, every day. Monday, Friday. Sure. Monday,
6
Friday.
weeks. That's like a full-time, well,
Wow.
not like full-time because it's 8 to 3, but almost full-time. That's crazy.
Well, each side has multiple attorneys, and presumably each side has staff, so that when unknowns, which we'll talk to later, when unknowns occur, somebody's sitting in the background, able to crank out some documents or do some research. But it is a little bit odd that they're saying that they want to work around the school schedule and not, whether or not they're prepared for a case in which, after all, the death penalty is on the table. The defense hasn't, as we do this podcast, they haven't directly responded, but they have come up with their own kind of filing that they filed right before we recorded this. And this is a motion to seal the defendant's motion for an interlocutory appeal. What this is they're not happy, the defense, with the fact that the judge in the case did not allow or denied their motions to dismiss the indictment So they are going to appeal that in the court or ask for reconsideration. And in the alternative, if that doesn't come, they want an interlocutory order and a stay of proceedings, as you can see in the last line. An interlocutory order is a request for this case to be bumped to another case. So the defense is saying here that they want to appeal the court's denial of their request to dismiss the case based on errors in the indictment. That's the interlocutory part of it. And they want to stay the proceedings. They want to stop the whole case until another court takes a look. So that's a little bit unusual. And so that will certainly throw a spanner in the works, as some people over on the other side of the pond might say, in this case. So the answer to the question as to whether or not the case will be tried in 2024, I think we've pointed out in previous episodes that some intelligent observers of this case have speculated that the trial won't be until 2025. So there we go.
Yeah, that's crazy. That's a lot. It's a lot to digest.
And if, we've always said on this show that, we respect Mr. Kohberger's right to a presumption of innocence until guilty. We're not saying he's innocent. We're not saying he's guilty. We're saying that we respect that presumption that he's entitled to under the United States Constitution. But if he is innocent, he's sitting in jail for an awful long time in the Lake County holding pen there. So let's go to the next question, which I touched on before. How many experts are there going to be in this case? And that's anybody's guess, but that is obviously something that was of concern when the prosecution filed their motion for a scheduling order. Who are the experts? How many experts? They don't even know. They want to know. In the Murdoch case, there were a total of 72 witnesses, and there were a lot of experts. There was a Snapchat expert. There were SLED experts. That's South Carolina law enforcement, experts on firearms and ballistics. Of course, no firearms that we know of anyhow in this case. So I don't think there'll be firearms or ballistics experts. There were multiple experts on smartphones, all kinds of experts in that case. I'm going to guess that the number of experts in this case, and I would bet short money on the fact that the number of experts in this case will be in the teens. I mean, what about acoustics? If you look at the probable cause affidavit, not just me, but a lot of people have questioned, how can someone be in their bedroom and hear someone else playing with a dog in the house, but not hear someone being stabbed to death in the next room? So what about an acoustics expert? What about a physiology expert? Don't people that are being stabbed to death wake up and emote, to put it nicely?
Fight back. I can't even imagine what that would be like. And that's one of the things too, where you mentioned all these different experts. It's just like, you can say like, oh, acoustics experts, oh, physiology experts, but they might even pull out things that we don't even consider. Another thing, I don't even know what level of expertise this would be, but there's been a lot of, back and forth with people in our comment section too, especially about what the house was like when it was dark. Like, how did, Dylan see this person, saw their face, the dark, everything. Just, I don't know. There's, I think, a lot of elements to this that are going to have experts that we didn't even consider.
No, you're right. But the ones we do know about would include at least one or two or more DNA experts. I mean, if you're the prosecutor and you have a DNA expert that says that, it's a slam dunk, and I'm the defense attorney, I'm going to say, no, it's not a slam dunk. Just wait a minute. I might have 3 DNA experts, and we'll get into the DNA in a couple of screens from here. So you're going to have a DNA expert. You're going to have smartphone experts. You're going to have cell tower experts. In a previous episode, we talked about a cell tower expert out in that area in Idaho and Washington State, who's already testified and said, this is not an easy case to say, oh, yeah, Kohberger, who drove around 12 times, and the other evidence of him, driving from here to there at 2, 3, 4. There's already been an expert who's testified in other cases as to the layout of the land in that area with respect to the cell towers and the pinging of the cell towers and what provable facts you can derive from all of that. So there will be experts on not only cell tower triangulation, but geolocation and all the other stuff about cell phones. There'll be an expert to testify as to, all right, if Mr. Kohberger had his iPhone turned off at the time of the alleged crimes, what information can be pulled out of that iPhone? There will be a criminology expert. What about a PhD in education? I mean, Mr. Kohberger was said to have gotten his degree in a school where they had a crime scene set up. Well, what did he learn? Would that have taught him how to commit a crime and cover it up, or did it not? And if it did, why did he make the mistakes that he made? So that's only the beginning. We could probably sit here all afternoon and I think lose our audience as we talk about all of the different areas in which there can be experts. But cases such as this have become a battle of the experts, and the attorneys, have to sit down and think really hard about how many experts they want. Because if you have your expert and I have my expert, a lot of times the jury is just going to say, "Oh, wait a minute, you know what? Forget that. Let's just go with the percipient witnesses." So
what makes it that somebody could be an expert? Can you essentially get anybody, like, even theoretically, like, I guess my thought is, if someone, this is just random, but like someone worked in some type of shop for 20 years, could that person be an expert? Is there some kind of like authorization that needs to go through for them to be able to be considered? Like, does the judge have to approve of them as an expert or something?
The answer to your last question is yes. Experts are qualified under a test that looks at their education, training, and experience. And in other words, before an expert is qualified to give an opinion in a case, the expert has to testify as to his credentials. Where did he go to school? What's his degree in? What did he study? That's his education. His training. Once you get out of school, you don't know anything. You got to actually go out in the field and do it and learn and be an apprentice, whether it's called that or not, and you learn under someone else's tutelage. And then their experience after their education and their training, what have they done? Have they testified in other cases? Have they written books? Have any of the articles that they've written, if they've written articles, been peer reviewed? So all of those three things are generally brought out in testimony. And then in some jurisdictions, you just keep going and you assume that the expert is qualified. In other jurisdictions, you have to actually turn to the bench and say, "Your Honor, I move that my witness be qualified as an expert." And then the judge either says yes or no. If he says no, you've wasted a lot of time and money. But anyhow, these things are generally taken care of pro forma. Some courts require that it be a little bit more formal. So that's that question. Then the next question becomes this DNA issue that's still out there. I mean, the judge, as we do this episode, still hasn't ruled on all of the evidence that he was given. Now, watch it. The minute we stop recording, they'll rule on it. But back on December 1st, the prosecution was required to provide all of their DNA evidence, and the judge was going to take it all in and decide whether all of the way that they got from the cells on the knife to Mr. Kohberger, whether that was, something that the defense should even be allowed to take a look at. I found an interesting article. There's a bunch of cases out there. There are a whole bunch of DNA cases. I looked at a bunch of them, and I'm going to show you one right now. It's a recent 2022 Connecticut case in which a man's conviction for assault was reversed on a number of grounds, to be honest with you. But one of them was the court's, real questioning of the validity of the touch DNA aspect of that particular case. And here's the case right here. It is the state of Connecticut versus Terrence Police. And that was actually the man's name, just so people can take a look at the case. And then we go down here and we see that what the court said is, touch DNA is a term used to describe DNA that is left behind by touching an object. Notwithstanding its name, however, touch DNA does not necessarily indicate a person's direct contact with that object. Rather, according to experts, Abandoned skin cells, which make up touch DNA, can be left behind through primary transfer, secondary transfer, or aerosolization. Internal quotation marks omitted. And they're quoting another case, State versus Dawson. That's a 2021, also Connecticut case. As a result, touch DNA poses potential problems that are not present or are less often present with DNA obtained from evidence consisting of bodily fluids. And they are referring to a very educational tome called Fishman and McKenna Jones on Evidence. For example, the court found touch DNA will often be available in much smaller quantities than DNA extracted from blood, semen, or hair. And the presence of touch DNA may often be far less probative of a defendant's guilt than DNA derived from bodily fluids. So the court in Connecticut is saying, listen, the DNA that we get from bodily fluids is something that is fairly reliable. But in this court, it's not really probative. It's not really going to help us know, rising to the level of whether or not this touch DNA can be considered in determining a person's guilt or innocence. And bear in mind here in the Kohberger case, this is a death penalty case. So where the evidence is questioned, that's a problem. And the final quote from this case, when dealing with such small amounts of DNA, there is a much greater ambiguity as to how the DNA ended up on the object. For example, the DNA could have been left by someone who touched the object, or even by someone who touched the person who then touched the object. In short, small amounts of DNA can easily be transferred and travel. Because of this, finding someone's DNA on an object is less significant to a determination of guilt or innocence of a subject. So that's just one of many cases that's out there. And I found that was interesting. And I will tell you that there's a bunch of cases out there similar to that just stand for the proposition that, okay, DNA is a great technology. It's been around now for 2 or 3 decades. But if there's a few cells found on a knife and it goes into a lab and goes through a couple of processes, even though they later matched a swab of Kohberger's DNA with what they say was the swab on the knife, there are a lot of questions as to how that cell or two of DNA was processed. So the courts have expressed real reluctance to rely on it.
Yeah, no, that's nightmare fuel. I don't know, like the idea of just anything that you touch or anything that you're near having your ID and then going off to someone else is really scary. And we hear about things going wrong, people found innocent years after they're convicted. Isn't, something that's groundbreaking. It's something that happens, it happens. Not that it happens more often than not, but it's something that has happened in the past. So I don't know. It's all really scary. Like just the idea that one day you touch something, like say you're going to a knife show and you want to touch a knife, you pick it up and then that knife's a weapon. Very scary.
It is. Okay, so now we go to number 2, surprises at trial. And even the most experienced person who's tried cases, even the most experienced trial attorney will have to admit to you that, there are always surprises at a trial. You do a trial outline, you do a trial memo, you do a trial plan, whatever you want to call it. You have plans, you know what's going to happen. You have notes, you have, who your witnesses are going to be. You have a good idea who the other side's witnesses are going to be. And you have a folder on each. They're all electronic now, or maybe not. The point is, things always happen. Things always rear their ugly heads at trial, and things often happen. And there are going to be a lot of surprises in this trial. I mean, notwithstanding the fact that everything has been gagged and everything has been sealed, all of that stuff will come out. But what else? What other stuff that we don't know will happen at a trial? Why do you think people watch this stuff on TV? Because the Hollywood producers don't hold a candle to what really happens in a real court trial.
Mhm. I mean, I think even just I keep bringing up the comments, but it's a reflection about how everybody has their different opinions on this case and how we don't really know what's going to happen. And like, because when you go into the comments, and we're going to go, little foreshadowing, is that some possibilities that, you don't even think of when you're reading and learning about the original case. Everybody has all these little side thoughts and sidebars, and we're going to get into one as our number one fact, that aren't really originally looked at. And it's interesting to see, the things that come up, and things that you wouldn't expect, especially like you said with the gag order. It's like we really have no idea of knowing what's about to happen.
So there will be surprises at trial, surprises beyond the stuff that we've even speculated on. And finally, talking of speculation, we've kind of danced around this issue in all of our previous issues. We've talked about, 10 things about the Kohberger case, 5 red flags in the Kohberger case, and we've kind of danced around this one. So, all right, by popular demand, we are going to take a look at Emma Bailey and Demetrius Robinson plus the pool party. So this is something that's been out there for quite a while. One of the sources, Howard Blum, and before you jump to the comment section and say, oh, that's been debunked. No, it hasn't. The man has won awards for his other journalism feats over the years. He's written for noted newspapers over the years. He's won awards over the years. So the man is credible. He's not just somebody that sits there and talks like us. He's a credible source. He is looking into something that no less than the FBI is looking into, and that Ann Taylor and the defense team is looking at, and that is Emma and Demetrius. Emma and Demetrius allegedly are dealers of drugs. There was a gentleman by the name of Caden Young who died of a drug overdose, and Emma and Demetrius were charged in that death, and they were held in court for several months. And days before that trial was supposed to go forward, just days before it was supposed to go forward, the case was dismissed on jurisdictional grounds, and it's never been brought back again. The two of them have been known to have connections with people that buy and sell drugs. Emma Bailey, interestingly, lives less than a mile from where the 1122 King Road house was. And if Mr. Kohberger had linked up with her, and this is just speculation, it's subject to an actual investigation by the FBI and others, it's possible that where they say in the probable cause affidavit that Mr. Kohberger drove around the 1122 King Road premises, was he really going there? Or was he going over to see Emma? Because we know that he allegedly had drug issues when he was younger, and she allegedly is a dealer. You can go into a lot deeper dive on this if you want, and I would suggest that you do go to Mr. Blum's article, because it goes much more deeply into all of this. Then there was a pool party. Actually, the pool party comes first. But what happened is when Mr. Kohberger moved from Pennsylvania to Washington State to pursue his education there, he met his neighbor, and his neighbor invited him to a pool party. And at the pool party, interestingly, everybody says, oh, he was such a wallflower. Oh, he, was always in the background. He saw a couple of girls. They were wearing black bikinis, and he went over to them and started talking to them, surprisingly. And he got their phone numbers. And this kind of went into the background, and nobody thought anything of it until the Idaho tragedies occurred. Then people started asking questions, and the FBI took an interest, and they started looking into the whole thing, and they got as much random video and pictures of that pool party. And the question was Emma Bailey there? And nobody could positively say she was there, but nobody could positively say she wasn't there. So in addition to talking to the two girls with the bikinis, did Mr. Kohberger somehow talk to Emma and link up with her then? And then the other thing the FBI was looking for, in that Mr. Kohberger was at this pool party, which was not far from Idaho State, by the way. The question was, were any of the Idaho 4 there? And there's a sheriff who is not part of the case, and so he is not bound by the gag order. And he was asked, and he said, I can't tell you that they were there, and I can't tell you that they weren't there, but, it's an open question. And the sheriff was also asked, were drugs a part of this whole thing? And he said, that would certainly answer a lot of questions, wouldn't it? So all of that's very telling. All of that's very interesting. And again, there's a much deeper dive on that, but it's all alleged at this time. It's all being investigated by the FBI, and we don't know what the results of their tests were. The FBI was a primary investigative agency in the Murdoch case, and it's also being investigated, we know for a fact, by the defense. So I don't like to talk about it too much more because, we could be here all afternoon talking about that rabbit hole or piece of the puzzle, but there it is, and it's not a pretty picture. We talked about how, and we're not shaming anybody for, or blaming victims, but it was a party house, and a party house is a party house, and the Urban Dictionary defines partying as drugs. So there it is.
Thank you so much, Andrew, for all the research that you do into the case. I know, we were seeing a lot of comments, and a lot of people were really, pressing and wanting us to kind of dive into that aspect. And I know one of your initial concerns was, oh, well, I don't know, what kind of information is out there, what we can confirm. And I know you really he has been head first doing his research into this. And I know that everybody watching, especially up to this point, appreciates how much work you do. So I do want to say thank you. Yes, thank you. And I know that this one, the whole pool party and Emma Bailey situation was a hard one to navigate. So
there's a lot more out there. There's a ton out there, and people send me stuff, and I read it, and I don't use it. I haven't used a lot of the stuff that people send me because it's just unlike the stuff I just talked about, which is being looked at by a bunch of different people who have a lot of credibility in this case and elsewhere. A lot of the stuff that's out there, it's just there are a lot of theories, but don't tell me you don't know what you're talking about if you don't know that they were standing out in the door smoking cigarettes at 8:30 in the morning, because I don't know that. I wasn't there, and neither do you. If you can send me a photograph with a timestamp on it, I'll put it on here, but don't tell me that I'm an idiot, because well, speaking of our commenters, do you want to read some of our comments that we get?
Sure.
Why don't you go first?
I have our first comment. Angeline Joven. In one of the videos from the body cam of the cops that stopped him on his way to Pennsylvania, his right wrist has deep cut on the outside. It's healing, but you can tell it's been there for a while. So I don't know about his physical afterwards and that he had nothing wrong with him. Not sure that's correct. But the fact is, he has a wound that is healing on his right wrist in one of those videos. And now it's interesting because while I didn't see the actual video that this person's addressing, I did see a screenshot of it. And I don't know, the screenshot to me, I'm curious what your opinion on this was, Andrew, because it looked like there was something, he had a brown mark, but I don't really know if it would be a wound. I
wasn't sure either. I remember seeing the picture. I don't, it's in the shade. He's leaning over. He's in the car. Sometimes when you bend over, your muscles go one way or the other. I don't know. That's a comment. Let me read the next two because they're really short. Wendy tells us, you guys have a great show. Thank you. Well, thank you, Wendy.
Thank you, Wendy.
And then there's Genevieve Smith, who says, Bryan Kohberger needs to confess the other people involved in the slayings he knows. All right, folks, we're just reading them. We're not verifying them. We're not saying it's true. We're not saying it's not true. We're just reading what our great viewers tell us.
I will say, though, in response to that one, that if he needs to confess the other people involved, if he knows other people that were involved, presumably he would say something as a plea deal, but we don't even know where the case is. We don't even know if we're having a case next year. So we'll see you in 2025. Let us know.
No.
Next comment from Kanoga Knuckles. I'm leaning towards BK innocence. The whole Ellie investigation is total clown show, biggest I've ever heard of. I do have one question about BK. This whole crime right in his backyard, was probably the most exciting thing that BK could have ever experienced. Someone working on this has a criminal PhD. You would think that he would be living MPD, talking to friends at MPD, immersing himself in every aspect of this case from every possible law enforcement courthouse source. But by all accounts, he was totally benign, strange to say the least.
Well, like I said before, he went to, smaller schools in LaSalle University in Pennsylvania and a community college. No disrespect to those people in those fine schools, and not to disparage anybody that wants to go to community college, because it's a great thing. But he didn't go to an Ivy League school. He didn't then go to, living in northeastern Pennsylvania, a state I know well. He didn't go to Boston or New York or New Jersey even, or Washington, D.C., where some of the top educational institutions in the world are. No, he went $2,500 west to Washington State University. Again, not to disparage any particular school, but that's the best he could do. And then, to repeat or emphasize a point I made earlier, so what? He had a degree. Is he an expert? No. I'll tell you that attorneys go to law school, and I don't care if they're number one in their class in the Ivy League school. They don't know how to try a case until you actually go into the courtroom and try a case and make a few mistakes and learn how to get evidence. But so my point is that I think people give him way too much credit for knowing so much about criminology. No, he wasn't an expert criminologist. No, they're out there, but he wasn't one of them. I'm sorry.
Yeah, I mean, anything you go to school for, or like anybody watching this, I think can empathize with. You go to school for something, you learn about it for 4 years, but sometimes you're going home and doing looking more into it. But a lot of the times it's not consuming your whole life. And a lot of the times, especially having something so close by, is very scary.
Okay, I got a creepy one to read here. This is from Paul Reynolds. You put your name on it. So he says that the blood smell was making all of them sick that morning. This is such total bull bleep. Whoa, wow.
The blood comments have the blood comments have the whole comment section divided, because some people either say they smelled that blood, or other people say they were closed doors, they couldn't possibly. So please let us know in the comments your opinion on that one, because I love hearing the back and forth justifications for that.
Yeah, I don't know. I guess I'm fortunate to never have been
near
enough to a horrible.
Yeah, thankfully we have no idea. Thankfully we've never been exposed to that, any crazy like that. Next comment from Rebecca Lee. As you already mentioned in the video, the household should remain until the trial concludes, just like the victim's body should have been held until they had a person of interest, an arrest made, and a conviction was made. In the same state of Idaho, they still have not released the bodies of JJ Velo and Kaylee Ryan. The families will not be given their bodies until the trials have concluded. So why did they release the victims' bodies in this case and allow the families to cremate them before they even had a person of interest? The defense had no way to argue against what the medical examiner and state claimed. And then this also has a note. Since this comment came out just in last week, the state just now released Kaylee's body. So little disclaimer.
Well, I don't know. It's hard to say. So I'm going to move along. I'll read two more, then we'll break. They're quick. You get the long ones. I get the quick ones. So this first one, trigger warning, Sigma Chi tortured them and made a snuff film. Come on, people. Don't you think if there was such a thing that it would be all over the dark internet by now? Because all kinds of other stuff, like in the Delphi case, all kinds of stuff that wasn't supposed to come out, came out. So I'm sorry. Okay. All right. And the last one we're going to read today is Lola, who has 2 subscribers.
Shout out.
Well, no, it's hard to get subscribers.
And Rebecca also has 275. Shout out everybody if you're making videos.
So our final comment is from Lola, and she says, if Bryan said that he wanted to know if there were other suspects, not just him, that makes the most sense. Well, that's a question that's up there. That is a question that's up there. In our last episode, we talked about how Bryan Enton quoted Mr. Kohberger, and it's not on tape or a written statement, but he quoted Mr. Kohberger saying, did they arrest anyone else? So it's hard to believe that one person, created the mayhem that was created at 1122 King Road on November 13th of 2022. It's just that's hard to believe, but, we don't know, do we?
Mm-hmm. Yeah, I do want to say thank you, everybody who comments and watches our videos and, are wonderful. I think we have 2 members. Thank you guys for that. And thank you just for all the love and hearing everybody's opinions. I always say this, but it really does make this so much more enjoyable. And it really does give us a million different places to start sniffing out. And thank you just so much for everybody enjoying these videos.
Don't forget our quiz for the day. Our quiz for the
Oh.
day is we have a new background. And so our quiz for our commenters is, what is the background that we're using today and where is it? And with that, please like and subscribe, and we hope that you all have a great day. You have been watching About the Law, a production of the law offices of Andrew D. Myers in Methuen in the Merrimack Valley of Massachusetts and in Derry, just outside of Manchester, New Hampshire. Remember to click the like and subscribe buttons down below. And if you enjoyed this video, be sure to share it with your friends and others. If you'd like to talk to me about an injury case, a car accident, a slip and fall, a serious bodily injury case, or some other case, please feel free to contact me. I'd love to talk to you. You can contact us through my website at attorney-myers.com. We have a contact us block, or you can call on one of the telephone numbers we've given there, or you can email me at andrew@attorney-myers.com. The foregoing is offered for informational purposes only. It is not intended as and does not constitute legal advice. Laws vary widely from state to state. You should rely only on the advice given to you during a personal consultation by a local attorney thoroughly familiar with state laws and the area of practice in which your concern lies. This podcast must be and hereby is labeled advertisement in some jurisdictions. And that's that.